that's why it's really important to have a plan and understand what your goals are.
In fact, my camel out there is suffering right now with a broken back.
So I actually found Pepe when it was only a couple of hours old, and I'm like, oh, this is a funny meme.
Oh my god.
Yo! Who is this Degen?
The old man is swing trading over years at a time. And it's like, that's where the real money is made.
The answer is a permanent loss. With single-sided staking, you don't have to worry about impermanent loss.
If you're aware, if you're disciplined, you can hone that into further financial growth.
Financial freedom, to where you can actually live life and not have to be constantly living paycheck to paycheck. I mean, that's the ultimate goal, more or less, right?
Jon Snow, your watch is not over. They released another document. Mr. President, a second document just hit the towers.
Oh my god, bro. I love, so like for the folks at home who don't know, we were in the green screen like post show, and we are like, oh man, would you guys look at Nuclear Herb's fucking Twitter page? Like, he is going bananas right now. And then I was looking at it and I scrolled down a little bit and I was like, 4 documents? Why does it say 4? We only read these fucking these 2 right here. So turns out apparently Richard Hart has responded to the response from the SEC. So I'm gonna read that for you guys here because our good Lord.
Stand by. I got a reference for you.
Yeah.
All right. Richard Hart. What do we got, Bruda?
Yes, this is
Today,
1 hour ago. He posted this.
Literally 7:06 p.m. All right. Timeline. July 31st, 2023. SEC complaint. April 8th, 2024. My motion to dismiss. Today, SEC opposition to my motion to dismiss. Today, right now, my reply to the opposition to the SEC's opposition, which means there's 2 big new public documents today and some exhibits. Next up, oral arguments, October 2024, Brooklyn, New York City. You know, if we're lucky, we might even get the New York City UFC card then. See some John Bones Jones fighting Stipe, but
ooh, that would be interesting.
One can only hope. True. Other than that, though, this is what we got. Will, are you taking this one?
I'm ready, bro. I'm fucking taking it.
All right.
So,
all right,
for the folks at home who don't know, I'm gonna do some reading. We're gonna talk
I'll
about
leave the screen share to you.
Excellent. All right. So, ooh, that looks pretty good. Oh, I can drag it wider and make it wider, or I can make it really small. Look at that. All right, cool beans. Enough fucking around here. All right, guys. So basically, Richard Hart's like, hey guys, this is actually, so we started the day off with like the old news, and then we're like, all right, we're finally done. Oh wait, just kidding. There's more. And now here we are again. So this is Richard Hart's reply memorandum in law in support of defendant Richard Hart's motion to dismiss. So we got the table of contents. I don't think we need to really go through all this stuff, but it's good to see the overarching information and things. I already took this document and threw it through ChatGPT. So we will just read the damn document and then we'll go through some stuff. All right. So preliminary statement. Defendant Richard Hart's motion to dismiss lays bare numerous glaring legal deficiencies in Plaintiff Securities and Exchange Commission's slapdash complaint. A pleading consistent with the SEC's ongoing haphazard campaign to punish people who create or interact with blockchain technologies. At the apex of these improper efforts is the current attempt to muzzle Mr. Hart using a narrative riddled with factual inaccuracies, cherry-picked statements, and misguided legal theories. Tacitly admitting its inability to defeat Mr. Hart's arguments for dismissal, the SEC now lobs in new putative evidence, twists its timelines to suggest that the alleged offerings were promoted long after they had concluded, peppers its opposition to Mr. Hart's motion, which with unpled, unsupported allusions to non-existent U.S. connections and conjures up new allegations found nowhere in the complaint. None of this can salvage the SEC's complaint, which should be dismissed with prejudice in its entirety. First, The SEC says almost nothing to rectify the complaint's jurisdictional shortcomings, and instead admits the complaint's insufficiencies by resorting to new purported evidence. But the SEC's 11th hour facts still fail because they either post-date the alleged offerings at issue, bear no evidence to the jurisdictional inquiry, or both. Second, the SEC attempts to overcome Morrison's bar on extraterritoriality by relying on authorities involving detailed U.S.-centric allegations not present here. Lacking such allegations, the SEC litters its opposition with references to the United States not found in the complaint or otherwise substantiated. The SEC cannot simply wish domestic transactions into existence. Third, the SEC fails to salvage its incoherent fraud claims, instead merely repeating its conclusory refrain that Mr. Hart's conduct was inherently deceptive. Alleged uses of funds that do not comport with SEC's preferences are not deceptive if no representations whatsoever were made about them. The SEC's incredulity and indignation that individuals would partake in the transactions at issue do not approach a viable fraud claim in the absence of anything fraudulent. Fourth, the SEC misunderstands that Mr. Hart's argument that an investment contract requires a continuing obligation, whether as part of a formal contract or an informal transaction or scheme. The complaint does not allege any such continuing obligation, so there is no investment contract here, and the federal securities laws cannot apply. Critically, the opposition identifies no case that says otherwise. Rather than address this point, the SEC spends pages responding to a hypothetical Howey test argument that Mr. Hart does not make in his motion. Building a straw house and then blowing it down does not address the legal argument Mr. Hart raises before this court. Bro, this is so much fun. All right.
This has got some pepper on it. Like
this is Richard Hart for sure. Oh man, I love it. Okay. Back to the document, folks. That was our some personal stuff. Fifth, the SEC fails to grapple at all with Mr. Hart's First Amendment arguments. It ignores the unconstitutionality of cobbling together purported securities entirely by cherry-picking words from hundreds of hours of public commentary of protected speech, resulting in content-based discrimination unsupported by a compelling government interest. The SEC also overlooks the unconstitutionality of its proposed injunction, which would dismantle blockchain-based public speech and impose a prior restraint on Mr. Hart's future speech by prohibiting him from interacting with communities that depend on blockchain in the exchange of ideas. Argument number 1. This court lacks personal jurisdiction over Mr. Hart. Apparently recognizing the complaint's failure to make a prima facie, to make a prima facie showing of personal jurisdiction, the SEC responds by jumbling together its jurisdictional allegations concerning the 3 software programs at issue, mischaracterizing the alleged timeline of events and introducing new purported jurisdictional facts. These efforts do not cure the SEC's failure to establish sufficient minimum contracts between Mr. Hart and the United States as to any of the 3 software programs and alleged transactions at issue. A. The complaint fails to establish personal jurisdiction relating to the alleged Hex offering. Mr. Hart cannot be dragged into a U.S. court regarding Hex software without a specific showing that his Hex-related activities were expressly targeted or directed to the United States. Reference this thingamajigger right here. The SEC does not dispute that anyone can execute the Hex software on the worldwide Ethereum blockchain network, making it a particularly non-territorial activity. Reference.
Ignore the rest of that.
Yep. Nevertheless, the SEC doubles down on its assertion that the mere execution of the Hex software by U.S. residents can satisfy minimum contacts, pointing to 10 U.S. residents who allegedly reported to doing so during the so-called Hex offering, compared to 21,156 wallet addresses that allegedly did so worldwide. More references. Those allegations are a far cry from what sufficed the SEC's cited authorities. SEC v. PlexCore entailed thousands of sales made by U.S. basic payment accounts, of which 90% were made in U.S. dollars and more than 25% to U.S. buyers, of whom the defendants were expressly aware. This looks like... Okay. That's a reference. In SEC v. Terraform Labs, PTE Ltd., the defendants signed agreements with US-based entities to facilitate the trade of the digital assets, and themselves stated while entering into one such agreement that 15% of the users were within the United States. Reference, reference, reference. And in EMI Christian Music Group Incorporated versus MP3 Tunes LLC, the defendant was aware both that his company had at least 400 users located in the forum, and that his company provided services to forum customers. Reference number. In contrast, Mr. Hart is not alleged to have any knowledge or control over whether or how many U.S. persons executed the Hex software, which, as the SEC tacitly concedes, is a unilateral activity. See reference. Thus, the SEC cannot show that Mr. Hart purposefully directed his activities at the United States. Burger King Corporation versus Rudesiewicz. And then there's some more quotations and references. YouTube and web content. The SEC claims that Mr. Hart targeted the United States by extensively promoting and marketing the Hex offering, specifically and directly to U.S. investors. Some references, emphasis added. As occurs frequently throughout the opposition, the SEC simply makes up its assertion regarding U.S. targeting. The complaint does not support it. Those cited complaint paragraphs reference online statements directed at no particular audience other than one alleged post-offering online chat concerning PulseX, not Hex. See references. Such untargeted, globally available online content cannot establish jurisdiction. More references. The SEC tries to establish Hex-related activities targeting the United States with a declaration referencing two alleged live video stream broadcasts to audiences in Las Vegas in March 2022 and September 2022, and an alleged interview in Miami on August 2022 that was live streamed on YouTube. During each of these, which Mr. Hart allegedly discussed Hex. Kleiman, that's a reference. These new allegations do not suffice, as merely speaking about Hex is not enough to show that Mr. Hart expressly targeted the alleged Hex offering towards the United States. But these alleged video broadcasts suffer from a greater problem. All three took place long after November 2020, the conclusion of the alleged Hex offering, quote unquote. After which Mr. Hart is not alleged to have offered or sold Hex tokens. More references. To establish specific jurisdiction, Mr. Hart's suit-related conduct must create a substantial connection with the forum. References. Discussing Hex more than a year after the alleged offering ended cannot budge the jurisdictional needle. Reference. Feeder funds created years after the plaintiff began investing in it were a forum connection too tenuous to support the exercise of specific jurisdiction. And then we have Starkistan versus Open Locker Holdings. No personal jurisdiction based on forum contacts post-dating sale of promissory notes because none of the aforementioned events giving rise to a liability occurred during that time period. So this looks like, Zenith, correct me if I'm wrong here, but this is just a bunch of references supporting their argument, correct?
Sorry, let me see this. Page 5.
So the rest of this paragraph here, can you see this?
Yeah, because it's all in parentheses.
Okay. All right. So I'm just going to skip all that then. All right. The timing of these alleged video streams is critical and sets Mr. Hart's case apart from the SEC purported authorities. See references. The defendants did business while traveling in the United States on a trip that took. Oh, this is a reference thing. Okay.
This is referencing the Plex score case.
Yep. Okay. Cool beans. So I'm going to.
No. Read that part. So in PlexCore, the defendants did business while traveling in the United States.
Got it. On a trip that took place at the start of the ICO pre-sale and allegedly interacted with U.S. persons over Facebook during the alleged offering. Terraform involved contemporaneous conduct such as promoting the digital asset at issue to U.S.-based customers and investors, retaining U.S.-based employees that had promoted the digital assets in the United States, and contacting with U.S.-based entities to facilitate the trade of digital assets. And Wilds v. BitConnect International PLC and Pino v. Cardone Capital LLC involve solicitations using social media, not social media appearances after the offerings ended, and neither concerned personal jurisdiction at all. See references. It makes no difference that these alleged video streams took place while Hex was being traded on the secondary market. As the SEC alleges, Hex can be traded on Uniswap, a third-party decentralized crypto asset trading platform. The SEC does not allege that Mr. Hart had anything to do with Uniswap, nor that he sold Hex tokens in any such so-called secondary market transactions, or even that such secondary market transactions are investment contracts at all. See SEC versus Binance Holdings Ltd. Distinguishing and dismissing secondary market claims. Thus, and then there's some more references, SEC versus Ripple Labs. Thus, this so-called secondary market does not pertain to Mr. Hart's suit-related conduct or give the SEC license to extend the jurisdictional timeline beyond the end of the alleged offering in November 2020. See Walden, and then there's references. The SEC also relies on ETHEX.com, a website that allegedly serves as one avenue by which individuals could execute a third-party Uniswap software, or could execute the third-party Uniswap software to trade Hex on the so-called secondary market. References. As explained above, Mr. Hart is not alleged to have anything to do with Uniswap software, and so-called secondary market transaction on Uniswap are not even an issue in this case. As such, ETHEX.com bears no resemblance to the website in PlexCore, which was a sales platform through which users could provide their credit card information and purchase the digital asset, thereby affecting the very sales at issue in the case. And then there's some more sources. Multiple U.S. residents used the website and created accounts to purchase the digital asset. In contrast, the SEC does not allege that any U.S. residents use ETHEX.com, making it irrelevant to the jurisdictional analysis. Some references. No need to address jurisdictional questions regarding a website without evidence from that forum residents used it. The SEC's other cases are also inapposite. Inapposite? I don't know what that means. Inapposite. Whatever. See Chloe v. Queen Bee of Beverly Hills, LLC. References. The defendants knowingly sold handbags to forum residents, purposely shipped them into forum state. And then also Kurtz v. Kurtz Hastings. The defendants purposefully sold products to forum state customers, albeit indirectly through an exclusive sales right agreement. Nothing similar is alleged here. Next is Kyle Barr. The SEC lobs in a declaration signed months before the complaint was filed from a person named Kyle Barr. See Declaration of Kyle Barr, thereafter Barr declared. The declaration states that Mr. Barr currently resides in the United States as of May 2023, but says nothing about his whereabouts during the relevant time period. Barr, and that's the reference. Nor does it give any indication that Mr. Hart, who allegedly interacted with Mr. Barr over the internet, had any idea of Mr. Barr's whereabouts. These deficiencies render Mr. Barr's declaration irrelevant to the jurisdictional inquiry. Even ignoring those threshold defects, Mr. Barr's declaration does not help the SEC. The SEC vaguely asserts that Mr. Barr was engaged to help develop Hex. But the declaration makes clear that Mr. Barr was a volunteer who heard about Hex on a podcast and wanted to devote his hobby time to learning and developing applications on the blockchain and thought Hex seemed like a good starter project for him. So he joined a public chat room, studied the Hex software code, and helped by answering questions about the code in the chat room, clarifying or checking Mr. Hart's answers about how the code worked, and proofreading website content. Although Mr. Barr allegedly wrote experimental and prototype code, there is no indication that Mr. Hart asked him to do so, and none of his code was used. Rather, the only Hex developer whom Mr. Hart allegedly hired, who is not alleged to have any ties to the United States, rewrote Mr. Barr's experimental and prototype code before it was deployed. Even if Mr. Barr were alleged to have lived in the United States at the time, his relevant activities did not otherwise pertain to the United States and are not an adequate basis for personal jurisdiction, which must arise out of the defendant's activities. Outdoor Partners LLC v. Rabbit Hole Interactive Core, and this is more reference. No personal jurisdiction based on a contractor who regularly conducted testing and debugging of the software in the forum. Internal quotation, blah-de-da. Okay, so just more reference stuff. Next one is Callahan v. Wisdom. The defendant could not reasonably anticipate being hailed into court in the forum merely by engaging a consultant who, purely incidental to his work for the defendant, was located in the forum. And then there's another one of Navarava SCIS LLC versus Acuity Forensic Incorporated. No personal jurisdiction based on a contractor's development and maintenance work in the forum. Moreover, none of what Mr. Barr's alleged activities relate to, or None of Mr. Barr's alleged activities relate to the alleged securities offering at issue, in contrast to the US-based employees in Terraform who promoted the digital assets in the United States, or the agent in SEC v. Stubos who carried out the fraudulent act at issue in the forum state on the defendant's behalf. Williams v. Preeminent Protective Services Incorporated also misses the mark, as that case involved a claim by an employee hired in the forum state concerning his employment, which therefore arose out of the defendant's forum contacts. More references. To find personal jurisdiction based on Mr. Barr's activities would force foreign software developers to ban US chat room participants from answering questions, writing practice code, or otherwise getting involved, an infeasible and draconian outcome without support in the law. Section B. The complaint fails to establish personal jurisdiction relating to the alleged Pulse Chain and PulseX transactions. The SEC does not dispute that individuals sent assets to the Pulse Chain and PulseX sacrifice wallets unilaterally, and that Mr. Hart had no way of knowing or controlling whether any of these anonymous transfers emanated from the United States. As with Hex, that lack of knowledge or control over whether U.S. persons did so nullifies the allegation that 10 U.S. persons reported sending assets to the Pulse Chain and PulseX sacrifices, compared to the 179,000 alleged sacrifice transactions. More references. The SEC claims that the Pulse Chain and PulseX websites contained tabs that invited users to click to learn how to purchase these assets, somehow making them interactive. References. That argument distorts the Zippo test beyond recognition. Clickable tabs are basic web design, not interactive content. Tabs or no tabs, websites that do little more than make information available to those who are interested in it are not grounds for the exercise of personal jurisdiction. Best Van lines, and then some references, and then more references. The alleged websites are a far cry from the Facebook accounts in PlexCore, which purposefully disseminated fraudulent messages to Facebook users in the United States, directed Facebook advertisements and messages containing fraudulent misrepresentations to potential users who were U.S. residents, and responded to questions. The SEC claims that Mr. Hart promoted the Pulse Chain and PulseX offerings through his video broadcast to the Hex conference in March 2022. But the evidence they cite tells a different story. This live video was allegedly broadcast to the post-offering Hex conference, not a Pulse Chain or PulseX conference, so that Mr. Hart could receive a Lifetime Achievement Award. During a nearly 2.5-hour discussion, Mr. Hart's alleged promotional statement was his observation that the Pulse Chain and PulseX software programs had product market fit because they had a lot of members in their chat rooms. Mentioning the number of people in chat rooms during a lengthy discussion at a conference for a different software program does not remotely suggest any promotion of the alleged offerings at issue. The SEC's reliance on this live video broadcast also fails when timing is considered. The complaint alleges that the so-called Pulse Chain and PulseX offerings ended on August 3rd, 2021 and February 26, 2022, respectively, but vaguely asserts that the offerings were unofficially extended until April 6, 2022, apparently based on Mr. Barr's unexplained statement to that effect. Mr. Barr's musing side, the SEC never alleges that anyone in the United States sent assets during this unofficially extended period to, or that Mr. Hart even hinted during the March 2022 broadcast that additional assets should be sacrificed. The SEC's unexplained, unspecific reference to the unofficially extended sacrifice period falls short of its obligation to provide non-conclusory fact-specific allegations or evidence supporting personal jurisdiction. And then there is more references to another case, Chirag v. MT Meridia Marguerite Schaeferts. Oh my God. Or Schiffarts, whatever, and cannot justify extending by months the jurisdictional timeline of the alleged offerings. While nothing more is needed to discard that allegation, public website and blockchain records underscore its lack of substance. As early as August 5th, 2021, Pulse Chain website warned, the sacrifice phase is over. Do not sacrifice any more money. And blockchain records indicate that well over 99% of transfers to the sacrifice wallets had taken place before the alleged March 2022 broadcast, making clear that the alleged offerings were over. The alleged August 2022 interview and September 2022 video broadcast are quickly dispensed with, as those took place long after even the unofficially extended offering periods for PulseChain and PulseX had ended. Moreover, the alleged broadcasts all took place before the PulseChain and PulseX programs were released in May 2023, such that there was no offering, sacrifice, token, or market of any sort at the time, flatly contradicting the SEC's contention that Mr. Hart promoted the PulseChain offering and encouraged U.S. investment in it during these alleged broadcasts. Accordingly, these allegations do not concern Mr. Hart's suit-related conduct relating to the alleged PulseChain and PulseX offerings and cannot form a basis for personal jurisdiction. And then there's some more references. Recommending dismissal for lack of personal jurisdiction, notwithstanding the defendant's appearance at 4 U.S. court-related conferences after the plaintiff already had investments in relevant cryptocurrency, and where there was no indication that the defendant's online materials were specifically targeted at the United States as opposed to the rest of the world. All right. Nor do these video broadcasts cure the SEC's failure to allege a jurisdictional nexus for the allegedly fraudulent PulseChain transactions, as they do not pertain to Mr. Hart's alleged deceptive conduct at all. See in Rayon Aegean Marine Petroleum Network Incorporated. Some more reference numbers. No personal jurisdiction over fraudulent scheme claim where alleged fraudulent conduct was not directed towards the United States. That leaves Mr. Barr's declaration, which does not suggest that Mr. Barr promoted or facilitated the sacrifice transactions or alleged offerings, or that he undertook any other conduct jurisdictionally relevant to the claims at issue. His declaration does not even suggest that he was involved in coding the PulseChain or PulseX software, contrary to the SEC's characterization that he was a developer who helped develop the programs. Rather, Mr. Barr allegedly helped with administrative tasks to facilitate hiring developers for the PulseChain and PulseX software, such as emailing potential developers and sending out contracts for signature. Mr. Barr's declaration does not state that he was doing these tasks in the United States, and even if he had, those activities would have been purely incidental to his living there, not relevant to the alleged securities offerings at issues, and not an adequate basis for asserting personal jurisdiction over Mr. Hart. Then there's more references, finding personal jurisdiction based on, in part, on U.S. employees promoting the digital assets of the United States. Section C. Exercising personal jurisdiction would not be fair or reasonable. The SEC does not dispute Mr. Hart's argument that asserting personal jurisdiction based on U.S. residents' use of globally available decentralized blockchain software would not comport with traditional notions of fair play and substantial justice. Hoping to avoid that serious policy concern, the SEC instead contends that the personal jurisdiction can be based solely on Mr. Hart's specific, repeated, continual, and successful targeted efforts to reach U.S. investors. The court should hold that the court should hold the SEC to that representation and refrain from considering U.S. residents' unilateral use of the blockchain in connection with the alleged offerings, the alleged ministerial assistance of a U.S. volunteer, or Mr. Hart's untargeted globally available statements. The SEC cannot meet its burden with the scant U.S.-related allegations that remain. Section D. The SEC has abandoned its purported alter ego claims. For this section, the SEC claims concerning purported entities serving as Mr. Hart's alter ego must be dismissed because the complaint fails to adequately allege that any such entities exist, let alone as Mr. Hart's alter egos. Apparently recognizing that it cannot sue software, the SEC does not respond or even mention the term alter ego in the opposition. The SEC choose consciously, by its silence, to waive and abandon any argument it could have made with respect to the alter ego activities. Tarrant v. City Mound. Okay, so this is a reference. All claims premised on the SEC's alter ego entity theory, therefore, must be dismissed. All right, now we're in subsection, or no, this is response
Argument number 2.
Argument 2, that's what it is. The SEC has failed to adequately plead the existence of a domestic purchase, sale, or offer of securities. Section A. The SEC fails to allege a domestic purchase or sale of securities in connection with its fraudulent claims. Subsection 1. The Dodd-Frank Act did not override Morrison's application to the SEC's fraudulent claims. The SEC argues that the jurisdictional provisions of the Dodd-Frank Act override Morrison with respect to the federal securities laws anti-fraud provisions by providing Morrison's requisite affirmative indication of the extraterritorial statutory application, and that the conduct and effects test therefore applies. The SEC is incorrect. As the Second Circuit has stated, the import of the Dodd-Frank amendments is unclear, since Morrison recognized that the court in that case had jurisdiction and extraterritoriality raised a merits issue. Some more references. Indeed, the plain language of the Dodd-Frank amendments does not clearly express the potential intent to rebuke the presumption against extraterritoriality. More references. Despite the SEC's heavily reliance on SEC versus Scoville, that the out-of-circuit decision does not control this court's analysis, nor overcome the Second Circuit's explicit questioning of the impact of the Dodd-Frank Act in Park Central. Accordingly, this court should apply Morrison to the SEC's fraud claims and dismiss them. Subsection 2. The SEC fails to satisfy the conduct and efforts test in any event. Even if the Dodd-Frank amendments resurrected the conduct and effects test for securities and fraud claims, the SEC does not satisfy that test. The SEC does not allege that Mr. Hart engaged in any conduct within the United States, but still argues that the conduct test is nonetheless satisfied because Mr. Hart discussed development work to give U.S. investors the reasonable expectation of profit, targeted U.S. investors through YouTube livestream videos and on the PulseChain.com website, and extensively marketed PulseChain in its development to U.S. investors, but supposedly targeting U.S. investors from outside the United States is not conduct within the United States. Moreover, this argument relies on the SEC's misrepresentation of its own allegations. None of those cited complaint paragraphs mention the United States or its residents at all. The SEC cannot circumvent the deficiency of or supplement the complaint by inserting in at to the United States in the opposition wherever convenient without any factual or even alleged basis. The SEC also argues that Mr. Hart did not restrict the ability of U.S. investors to access his YouTube videos, view the PulseChain.com website, or invest in PulseChain. But the complaint contains no mention of alleged failures to restrict U.S. investors, nor has the SEC set forth any authority for the proposition that lack of conduct is equivalent to affirmatively targeting U.S. persons. This is obviously not the law. See Interview v. Braskin Court. Effects tests do not satisfy despite U.S. investors participating in the transaction, where the U.S. investors were neither the intended nor the actual victims. The SEC also fails the effects test, which requires conduct to have a foreseeable substantial effect within the United States. The only alleged PulseChain related effects consist of one investor in Brooklyn and an unspecified amount of crypto assets invested by investors in the United States. Given these paltry allegations, this court cannot find that the fraud would have had a substantial effect in the United States or upon United States citizens. Cornwell v. Credit Suisse, internal quotation omitted. So that's just some references. All right, Section B. The SEC fails to allege domestic offers or sales of securities under Section 5. Subsection 1. The SEC fails to allege domestic sales of securities as to its Section 5 alpha claims. In attempting to salvage its Section 5 alpha claims, the SEC unduly relies on the recent decisions in Williams v. Binance. Therefore, the court held that the plaintiffs had plausibly alleged facts showing that two transactional steps giving rise to an inference of irrevocable liability occurred within the United States. The court, 1, found that the transactions at issue were matched and therefore became irrevocable on the defendant's servers located in the United States, and 2, accepted the interrelated allegations that when plaintiffs transacted on the defendant's platform from the United States and pursuant to the defendant's terms of use, their buy orders became irrevocable where they were sent. The court also observed that the defendant now has a substantial presence with servers, employees, and customers throughout the country. ID at 133, but focused on where buy and sell orders were matched. Here, the complaint includes no comparable allegations. The SEC does not allege that any alleged transactions were matched. There were no buy or sell orders and no exchange platform upon which the alleged offerings took place. Rather, alleged offerings involved unilaterally executing the Hex software or sending access to sacrifice wallets. There was no alleged infrastructure nor any orders to match anywhere, let alone in the United States. The few allegations in the complaint that even mention the United States lack the specificity present in Williams. See this reference number. The SEC alleges that one Pulse Chain investor resides in Brooklyn, and the 3 software programs had an unspecified number of investors in the United States or wallet addresses that belong to investors in the United States. These allegations do not even state whether these individuals took any actions in the United States, let alone plausibly establish that they incurred irrevocable liability there. The SEC also argues that the second prong of the Williams analysis, about transacting from the United States pursuant to the defendant's terms of use, constituted a second separate bias for irrevocable liability. Not so. In fact, the Second Circuit expressly observed that the alleged entry into terms of use, placement of purchase orders, and transmission of payments from the United States were a second interrelated reason that irrevocable liability attached in the United States. Moreover, even if Williams had suggested that this second theory could be independently sufficient in that case, the Second Circuit specifically found reason to consider where the plaintiff's trades originated, given that the defendant expressly disclaims having any physical location, foreign or otherwise. The SEC alleges no such express disclaimers here. Indeed, the SEC alleges that Mr. Hart resides in Finland, a country with its own securities laws that, in contrast to Williams, is not alleged to have disclaimed responsibility for regulating. The other cases cited by the SEC are inappropriate, are inapposite. Inapposite? I don't know. Some word that looks like opposite, but with an A. The other cases cited by the SEC are inapposite. The court determined that irrevocable liability attached to the United States because of substantial U.S. connections, including material misrepresentations made at an in-person meetings in New York and an underlying agreement being formed in the United States. In United States v. Villar, the defendant held in-person meetings within a U.S. territory and had significant correspondence with U.S.-based purchasers, leading to the purchasers incurring irrevocable liability within the United States. By comparison, the complaint contains a single allegation that Mr. Hart had an online chat about the PulseX software with someone in New York after the alleged offerings had concluded. This allegation bears no resemblance to those found sufficient in the SEC's cited authorities. Subsection 2. The SEC fails to allege domestic offers to securities as to its Section 5 Charlie claims. The focus of offer under the Securities Act is on the person or entity attempting or offering to dispose of or soliciting an offer to buy securities. It's SEC via Goldman Sachs, and this is a reference. It is the location of the offers here, Mr. Hart, that is relevant. SEC versus Ripple Labs, more references. The SEC does not contend that Mr. Hart made any offers within the United States. Retreating to an out-of-circuit case, SEC versus Balina, the SEC argues that the complaint sufficiently alleges that Mr. Hart engaged in a targeted marketing campaign that was directed at U.S. investors and therefore offered securities in the United States. As discussed above, suprasection 2, some more references, the SEC cannot simply sprinkle the words United States throughout the opposition to try and fit this case within Balina. Casting aside these mischaracterizations, the complaint merely references investors in the United States, which plainly does not suffice. Section C. Transactions the SEC alleges are predominantly foreign. The SEC does not dispute that binding Second Circuit precedent holds that a domestic transaction under Morrison is a necessary, but not necessarily sufficient, condition to pleading a claim under federal securities laws. Both Morrison and the Second Circuit's decisions in Park Central and Calavello Bay Reinsurance Ltd. v. Schubeinstein prescribe a focus on the transaction rather than the surrounding circumstances, and instructs courts to flexibly consider whether a claim, in view of the security and the transaction as structured, is still predominantly foreign. Morrison's domestic transactions rule operates as a threshold requirement and as such may be under-inclusive. Predominantly, foreign claims must be dismissed. Here, the digital assets at issue are listed on no U.S. exchange and are not otherwise traded in the United States. The claims arise out of a non-resident publishing globally available software and speaking about it on an internet forum abroad. The SEC's only response is to repeat its unsupported assertion that U.S. investors purchased each of these assets after a promotional and marketing campaign that reached into the United States. That is not enough as a matter of law, nor is that characterization supported by the allegations as explained above. The sparse contracts actually alleged in the complaint cannot justify extraterritorial application of the federal securities laws. It is a rare case of prohibited extraterritorial application that lacks all contact within the territory of the United States, quoting Morrison, and then there's some more reference numbers. All right, argument number 3. The complaint fails to state a claim for securities fraud. Section A, the SEC fails to plead deceptive conduct. The SEC concedes that it has not brought claims for fraudulent misstatement or omission. Thus, the SEC is only asserting claims for a fraudulent scheme, which require particularized allegations of deceptive conduct. The SEC contends that alleged expenditures of certain pulse chain sacrifice assets were a misuse of investor funds, and that this alleged misuse was an inherently deceptive act. Both contentions are wrong. First off, nothing supports the SEC's conclusory contention that the pulse chain sacrifice assets were investor funds at all. The SEC has no response to Mr. Hart's clear disclosures that the sacrifice assets were just that, sacrificed, lost, and gone, with no expectations from those who sacrificed them. The SEC's assertion that those assets could nonetheless be misappropriated as an unwarranted deduction of fact that cannot be credited under Rule X, Y, and Z, PDQ. These are some reference numbers. Moreover, the SEC's cited authorities do not support the proposition that of the alleged expenditures were somehow inherently deceptive. Those cases found fraudulent schemes based on alleged dissent. So here's a reference where a stockbroker defrauded his clients by selling their securities and spending the proceeds on himself because the clients were duped into believing the defendant would conservatively invest their assets in the stock market. And then there's another reference where the defendants took over dormant corporations by filing deceptive documents with secretaries of state and false documents with the NASDAQ, and then used those corporations to deceive shareholders about the true identity of the issuing company. Here, no duping or deception is alleged, so no securities fraud claims exist. Mr. Hart did not tell anyone that the sacrificed assets would be held in custody, protected, invested, or used for any particular purpose. To the contrary, he told everyone up front that any assets they sacrificed would be lost and gone. The SEC tries to blow past the plain meaning of what Mr. Hart says, that assets would be sacrificed, to argue without support that Mr. Hart has still had some unexplained obligation to ensure that the sacrificed assets were used in certain ways and not others. Even humoring that unsupported theory, the SEC still comes up short, because misappropriation without deception cannot constitute securities fraud. In Zanford, the Supreme Court made clear that if the broker told his clients he was stealing the client's assets, that breach of fiduciary duty would not involve a deceptive device or fraud. Other courts have firmly rejected that SEC's theory that misappropriation is inherently deceptive and is enough to state a claim for a violation of the securities laws, noting that the SEC is incorrect as a matter of law. SEC v. Sugarman, and then there's some more references. But to paraphrase or to sum it up, courts must parse fraud allegations to distinguish between misappropriation that is a mine run conversion and a misappropriation through deceptive conduct. See also Santa Fe Indus Incorporated v. Green, holding that a breach of fiduciary duty without deception does not constitute securities fraud. United States v. Finnerty, holding that the garden variety conversion of assets does not give rise to a scheme liability securities fraud claims in the absence of deceptive conduct. The SEC also asserts that the ways that the sacrifice assets were moved on the blockchain constitute deceptive acts. That theory similarly fails because the SEC does not establish that any assets were misappropriated in the first place. Deception cannot exist here, where no one was plausibly entitled to an expectation as to the location, use, or movement of such assets. The SEC has no response to this. Nor does the SEC allege anything deceptive about publicly recorded blockchain transactions it references. The SEC recharacterizes 22 alleged back-and-forth transactions as an effort to disguise the movement of approximately 26 million in Ethereum. Some references, but the complaint alleges that those were swaps exchanging a stablecoin called Tether for the Ethereum blockchain native token Ethereum, or ETH. 26 million of Tether was transferred from the private wallet in 22 back and forth transactions, resulting in approximately $26 million of ETH being deposited into the private wallet. Exchanging one common cryptocurrency for another through public blockchain transactions does not suggest that anything was disguised or anyone deceived, because such transactions are both plainly visible and plainly ordinary. See Finnerty, rejecting the conclusory assertion that the scheme was self-evidently deceptive. The SEC's allegations concerning the use of crypto asset mixer fare no better. Anyone who sacrificed assets, knowing that they would be lost and gone, could not have had any expectation as to wherever those assets then went, including via public blockchain transactions to a mixer program that allegedly facilitates anonymous transactions. To the contrary, such assets were sacrificed and gone. Thus, Mr. Hart's express disclaimers disclose the very risks about which the SEC claims to have been misled. Unlike here, where individuals were put on accurate specific notice, the SEC's inapposite authorities involve sham companies or transactions used to give the victim a false impression. Due diligence, and here's a reference of an example. Fake due diligence payments to a sham entity gave the misleading impression that funds were being used for due diligence. And then here's another reference. Use of sham entity to hide the source of a purchase through series of fraudulent transactions. Another reference, use of some contractor entity to obscure the fact that the defendants would reap the benefits of a discounted rate. Nothing comparable is alleged here. Next, we got Section B. The SEC fails to support its scheme claims with alleged omissions. Subsection 1. The SEC cannot assert scheme claims based on alleged omissions. The SEC cannot establish scheme liability without alleging an inherently deceptive act that is distinct from an alleged misstatement. Some references. Accordingly, this court must scrutinize the SEC's pleadings to ensure the misrepresentation or omission claims do not proceed under the scheme liability rubric. There's some more references and some more references. The SEC argues that the alleged omissions regarding pulse chain assets can still form a part of the SEC's scheme claims, as long as these omissions are paired with other deceptive conduct, namely the aforementioned alleged expenditures and movement of assets. But as explained above, none of that conduct was deceptive. Left with no inherently deceptive act that is distinct from the alleged omissions, the SEC scheme claims to fail, whether or not the SEC could have alleged materially misleading omissions. Subsection 2. The SEC identifies no misleading omissions to support its scheme claims. Putting aside that threshold defect, the complaint identifies no misleading omissions, let alone material ones, to support its purported scheme claims. The SEC asserts that by saying that nobody could have any expectation about the sacrificed assets, which were lost, gone, and not going to charity, Mr. Hart somehow then became obliged to tell the whole truth about how such sacrificed assets would be used. That assertion makes no sense, as it would paradoxically require full disclosure of a subject every time someone disclosed that they would not be speaking about it. The assertion also ignores the bedrock principle that the federal securities law do not create an affirmative duty to disclose any and all material information. And then there's some references. Courts have made clear that the mere reference to a topic does not require disclosure of the entire corpus of the person's knowledge relating to it. More references. Thus, silence is not actionable unless the omission renders affirmative statements made misleading. More references. Indeed, even the liability in Vivendi was predicated on the defendant's statements, not its silence. And this is in reference to Vivendi, and then there's more reference numbers. The SEC's theory boils down to a contention that people would have wanted to know about the use of sacrifice assets, but a person is not required to disclose a fact merely because a reasonable investor would very much like to know that fact. Fatally absent from the SEC's theory is how Mr. Hart's expressly forewarned silence, as to subsequent uses of the sacrifice assets rendered any of his prior statements materially misleading. The assets were gone, just as he stated, and he was not obligated to provide any further information. And then there's a reference, not misleading to omit the true reason for an executive termination from a press release. Another reference, not misleading to omit information about a hypothetical divestiture. And then another reference, no duty to disclose financial difficulties where omission did not render prior statements materially misleading. The SEC claims that Mr. Hart feigned ignorance about where investors' funds had actually gone because he stated that they would not go to charity to the best of his knowledge, while knowing full well that millions of dollars of those invested funds had been and would continue to be funding his personal purchases, quote unquote. The SEC again twists up its timeline, pretending that Mr. Hart made the quoted statement in November 2021 rather than July 2021. Given that the sacrifice was allegedly still ongoing as of July 2021, the alleged expenditures had not yet begun, and the alleged expenditures amounted only 2.5% of the assets, qualifying Mr. Hart's limited perspective about how the sacrifice assets may or may not be used is not plausibly misleading. Nor was it misleading for Mr. Hart to speak about free speech ideals or development and marketing without also disclosing the use of sacrificed assets. As the SEC does not allege that Mr. Hart ever stated that the sacrificed assets would be spent on those subjects. Thus, the SEC has identified no misleading omission that could make up even a part of a deceptive scheme claim. Section C. The SEC fails to plead scienter. The SEC claims that Mr. Hart acted with fraudulent intent because he knew that the alleged expenditures were being made with funds from investors, quote unquote. But the SEC does not adequately plead that the sacrificed assets somehow constituted investor funds, and it offers no answer to Mr. Hart's clear and truthful disclosures regarding the consequences of the sacrifice. Nor does the SEC dispute that Mr. Hart's only alleged promise was to launch Pulse Chain and release Pulse tokens, and that he is alleged to have done precisely that. The SEC cannot concoct a strong inference of fraudulent intent based on movements of sacrificed assets either. These movements are consistent with Mr. Hart's disclosure that the assets would be gone, and that no one should have any other expectations. The more cognate and compelling inference is that Mr. Hart took his own statements and disclaimers seriously. And there's more reference numbers. The SEC's disdain for the Pulse Chain software program and associated sacrifice does not make up for the incurable absence of the coherent, factual, or legal basis for a fraud claim, the assertion of which inflicts injury not only upon Mr. Hart, but upon the communities who execute the software programs at issue. These claims should be dismissed with prejudice. And I don't think I need to read this footnote here, but there's a footnote for those that are interested in reading it. Argument number 4. The opposition does not address that the complaint's failure to adequately allege that any parties entered into an investment contract. Section A. The complaint does not allege that the existence of a contract, transaction, or scheme that created continuing obligations for Mr. Hart or anyone else. Hoping to recast the software programs at issue as investment contracts, the SEC mischaracterizes Mr. Hart's arguments and Supreme Court and Second Circuit precedent. But that effort cannot alter the fact that the SEC has failed to allege the existence of a contract, transaction, or scheme that creates continuing, i.e. post-purchase, obligations for Mr. Hart or someone else to generate profits for individuals who execute the Hex, Pulse Chain, or PulseX software programs. Without any such continuing obligations, the Hex, Pulse Chain, and PulseX software programs are not investment contracts and therefore not securities. As an initial matter, the SEC does not allege that there were any written or oral contracts concerning the Hex, Pulse Chain, or PulseX software programs. Instead, the SEC exclusively relies on the assertion that the Hex, Pulse Chain, and PulseX software programs are transactions or schemes whereby a person invests his money in a common enterprise and is led to expect profit solely from the efforts of the promoter or a third party. The opposition ignores the fact that to qualify as investment contracts, quote unquote, such transactions or schemes, even if not formal contracts, must still impose continuing obligations on an offerer or another person to generate profits. Without that limitation, the sale of any asset that a buyer hopes will increase in value could constitute an investment contract, quote unquote, thereby vastly extending the SEC's enforcement authority beyond its current purview. This prerequisite, which prevents overreach by the SEC, is implicit in the definition of an investment contract set out in Howey and has been affirmed by subsequent Supreme Court decisions. And then there's a whole bunch of references for Howey. emphasizing an offeror's obligations to manage, control, and operate the enterprise. And then another reference, holding that shares of stock in a housing cooperative that entitled purchasers to a lease were not securities because such purchasers had no expectations of profits from the efforts of others. There's a final Marine Bank v. Weaver reference where Congress intended that securities laws to cover those instruments ordinarily and commonly considered to be securities. Okay. Continuing. The existence of an investment contract therefore requires such a continuing obligation. And then here's a reference, relying on the offeror's implicit through formally disclaimed or though formally disclaimed intention to remain involved post-transaction in holding that the relevant cryptocurrency was an investment contract. And then there's another reference highlighting the offeror's lack of post-transaction involvement in holding that insurance contracts at issue were not investment contracts. The SEC inaccurately argues that Mr. Hart cannot point to a single decision at any level of judiciary endorsing, or at any level of the judiciary endorsing the continued obligations requirement necessary to find a contract, transaction, or scheme under the securities laws. Mr. Hart's motion itself easily debunks that argument, as it addresses not only the implicit presence of this requirement in the Howey and its progeny, but also Second Circuit precedent that emphasized offers continuing obligations to purchasers when finding investment contracts and a lack of continuing obligations when finding no investment contracts. Mr. Hart is not asking the court to impose a new requirement for investment contracts, as the opposition suggests, but rather to enforce a prerequisite well-founded in precedent. The opposition misreads Mr. Hart's motion as inviting the court to read a contractual obligation requirement into the Howey test. But the motion does not once refer to a contractual obligation, and Mr. Hart has never argued that a formal contract is required. Rather, the critical point missed by the SEC is that continuing obligations, whether formally documented, a contract, or steadily apparent from the totality of the circumstances, a transaction or scheme, are integral to finding an investment contract. And then there's a reference in searching for the meaning and scope of the word security. Form should be disregarded for substance, and the emphasis should be on economic reality. And that's citing Howey. And then there's another reference here, holding that it is unnecessary to determine whether the continuing obligation at issue was enforceable as a legal right in determining that it could underpin an investment contract. Even the recent cryptocurrency cases the SEC cites support this precedent, with each court emphasizing an offeror's commitment to involvement in the development and growth of the relevant cryptocurrency or ecosystem, whether or not a written contract expressly required it to do so. For instance, the court in SEC versus Terraform Labs concluded that a technically valid written or oral contract was not required because the parties could also informally agree, that is, scheme, that the contractee will make an investment of money in the contractor's profit-seeking endeavor. There's another reference, SEC versus Coinbase, SEC versus, and then Binance, and then some other things, just a whole bunch of references, Terraform Labs, Ripple, Kick Interactive, etc. In sharp contrast, the opposition simply fails to address the complaint's plain lack of allegations that Mr. Hart or anyone else had any similar continuing obligations to individuals who choose to unilaterally execute Hex, PulseChain, or PulseX software programs. That pleading failure distinguishes this case from the ones above and precludes the finding of either formal contract or, as in Terraform, an informal transaction or scheme. Without such a finding, no investment contract exists and the federal securities laws cannot apply. Section B. The opposition misinterprets Mr. Hart's continuing obligation arguments as a dispute about the Howey test. Misunderstanding Mr. Hart's arguments, the SEC dictates that a significant portion of the opposition to countering an argument that he does not make. Section 4 Bravo of Mr. Hart's motion does not argue that the complaint fails to allege facts sufficiently to satisfy the Howey test. Rather, that section thoroughly establishes that the complaint fails to allege any contracts, transactions, or schemes that impose continuing obligation on Mr. Hart or anyone else to generate profits for those who execute the Hex, PulseChain, or PulseX software. As discussed above, the existence of such a contract, transaction, or scheme is a fundamental prerequisite for an investment contract. Despite its insistence that this court consider the totality of the circumstances, the opposition exemplifies that the SEC's tendency to cherry-pick allegations convenient to its Howey analysis while ignoring scores of statements contradicting its predetermined outcome. Constrained by the Rule 12 Bravo Section 6 standard, and notwithstanding the contradictory facts and statements included in the complaint, Mr. Hart does not at this stage challenge the distorted record the SEC has created to plead the Howey factors. To the extent that any aspect of the complaint survives Mr. Hart's motion, Mr. Hart is confident that a fully developed factual record will show that Hex, Pulse Chain, and PulseX are not investment contracts, based on the Howey test. He looks forward to making the argument at the appropriate stage of this litigation. Nevertheless, it bears noting that even here at the pleading stage, when all allegations are presumed true, the SEC routinely resorts to misrepresentations about its own alleged facts. For example, the SEC falsely asserts that Mr. Hart stated he would use the funds to develop the Hex ecosystem. Nothing in the complaint supports that assertion. The SEC simply stated it to suit its litigation position. The SEC also mischaracterizes the complaint as alleging that funds were used to develop PulseX, and that Mr. Hart was deploying investor capital, when no such allegations exist in the complaint. As another example, the SEC inaccurately claims that Mr. Hart touted that an investment in the Pulse Chain offering would result in at least 14,000 times return on investment, while the actual underlying allegation is that Mr. Hart said such a return is a reasonable estimate for what could be possible. The SEC also continues to claim that PulseX, as the tokens Pulse and PulseX, are practically worthless, while ignoring judicially noticeable data showing that the assertion to be unmistakably erroneous. In weighing Mr. Hart's motion, the court should bear in mind the SEC's inability to stand by and constrain itself to its own complaint. Section 5. The complaint unconstitutionally infringes on the First Amendment rights of Mr. Hart and thousands of individuals who use Hex, Pulse Chain, and PulseX. The opposition mischaracterizes each of Mr. Hart's First Amendment arguments, and in doing so, sets up strawmen so that the SEC proceeds to knock down. But the opposition fails to even grapple with, let alone refute, the arguments that Mr. Hart actually makes. First, the SEC wrongly asserts that Mr. Hart broadly argues that the SEC is not allowed to refer to his public statements in support of his claims. The SEC does not merely refer to Mr. Hart's public statements. Instead, the complaint rests almost exclusively on Mr. Hart's public political speech, which is why the SEC's position infringes on his First Amendment right to free speech. Far from countering this argument, the SEC instead doubles down on the offense. It argues that Hex, Pulse Chain, and PulseX are investment contracts, rely not on economic realities of the software programs, but on cherry-picked excerpts from Mr. Hart's protected speech. As just one example, the SEC repeatedly cites statements Mr. Hart allegedly made on December 29, 2021, but never acknowledges that the statements were made over the course of a 7-hour discussion of countless topics that enjoy First Amendment protections, including the global economy, the economical effects of blockchain technologies, and the media industry. Holding Mr. Hart liable based on out-of-context quotations plucked from that protected political speech would severely chill his and others' ability to exercise their constitutional right to free speech. See Counterman v. Colorado, and that's some reference numbers. As the Supreme Court explained, prohibitions on speech have the potential to chill, or deter. Prohibitions on speech have the potential to chill or deter speech outside their boundaries. A speaker may be unsure about the side of a line on which his free speech falls, or he may worry that the legal system will err and count speech that is permissible as instead not. The result is self-censorship of speech that could not be prescribed, a cautious and restrictive exercise of First Amendment freedoms. And then they omitted the quotations and citations. The SEC's nearly exclusive focus on Mr. Hart's political speech as the basis for the complaint distinguishes this case from those the SEC cites for the proposition that the First Amendment does not prohibit the evidentiary use of speech to establish the elements of crime or to prove motive or intent. And then there's a reference to Wisconsin v. Mitchell. Okay, here we go. In such cases, conduct was at issue. The speech was used as a means of proving some fact about that conduct. For example, in Mitchell, the selection of a rape victim based on race. By contrast, here, the SEC seeks to unconstitutionally penalize Mr. Hart's political speech selectively, where such speech alone is at issue. See McIntyre v. Ohio elections, and then there's some reference. The reference is a government burden on core political speech must meet exacting scrutiny, meaning that it must be narrowly tailored to soothe an overriding state interest. And then there's another reference, equal employment opportunity versus Day and Zimmerman, MPS Incorporated. It is likewise inappropriate. There, the court found that employer could be liable for retaliating against an employee only after determining that the retaliation falls outside the scope of the First Amendment's protections. Here, Mr. Hart's speech is not categorically excluded from First Amendment protection and is not used merely as evidence of some other fact. His political speech is the SEC's case. Second, the SEC's contention that its enforcement of securities laws is inherently content neutral misconstrues Mr. Hart's arguments. As noted above, the complaint relies almost exclusively on the content of Mr. Hart's speech and thereby seeks to distinguish favored speech from disfavored speech on the basis of the ideas or views expressed. And then there's more references where they say, if it is necessary to look at the content of the speech in question to determine whether the speaker violated the regulation, then the regulation is content-based. The SEC's case consists of selectively excerpting portions of Mr. Hart's political speech and claiming that the words allegedly transformed software into securities because of their content. For instance, Hex is a security because Mr. Hart hyped its potential for investment gain. Or PLS is security because Mr. Hart publicly stated that Pulse Chain would be a fork of the Ethereum blockchain, but it would be 4 times faster and cheaper to use than Ethereum. The complaint must therefore pass strict scrutiny to survive, and the SEC's rote and generic invocations of its compelling interest in enforcing the federal securities law, with no discussion of any narrow tailoring, cannot clear this hurdle. Even if intermediate scrutiny were to apply, the complaint does not pass constitutional muster, as the SEC makes no attempt to show how muzzling or imposing staggering and imposing staggering monetary penalties on Mr. Hart for his speech and destroying 3 expressive communities is no greater a restriction of the First Amendment freedoms than is essential to the furtherance of the SEC's interest in enforcing securities laws, especially as it relates to registration violations. Third, the SEC's reliance on case law permitting regulation of speech employed directly or indirectly to sell securities misses the mark. In each of the SEC's cases, there was no dispute that the speech at issue related to securities. And then there's some references. Here, by sharp contrast, whether Hex, Pulse, and PulseX are securities is precisely the question at issue. The SEC cannot rely on case law permitting specific regulations of speech about securities to defend its use of speech and speech alone to establish that the software program at issue here are securities in the first place. That circular argument would permit the SEC to sidestep the First Amendment and at will simply by asserting that speech it did not like was related to securities without first establishing that any securities are even involved. Fourth, the SEC offers only a superficial defense of the devastating effect that it seeks to impose on the Hex, Pulse Chain, and PulseX public squares, each of which is populated by tens of thousands of individuals, including Mr. Hart, who exercise their rights of free speech and free association through these software programs. There's a reference. The SEC does not seek to remove Hart or any crypto enthusiast from the internet. Indeed, the SEC does not respond at all to Mr. Hart's argument that the SEC desired relief would entail the destruction of the Hex, Pulse Chain, and PulseX software as a public fora for speech, as the complaint effectively seeks to enjoin their very existence. The lack of response is fatal, as even if the SEC could establish that Mr. Hart's speech was unlawful, which it cannot, the government may not suppress lawful speech as the means to suppress unlawful speech. And this is from Ashtoff v. Speech Cole. That is precisely what the SEC seeks to do here. Suppress the lawful speech of tens of thousands of individuals who execute the Hex, Pulse Chain, and PulseX software to suppress and penalize Mr. Hart's speech. Section 6. Or this is argument 6, which I don't
Argument
remember.
number 6.
Argument number 6.
This is a new
All right.
one. This is a new one.
Okay. All right, excellent. The SEC should not be granted leave to amend the complaint. The SEC requests leave to amend its complaint if part or all of it is dismissed. That request should be denied. The SEC has brought a case based principally on public statements and public blockchain transactions that have been available for years, has reviewed Mr. Hart's pre-motion letter and motion, has supplemented its jurisdictional allegations with evidence outside the complaint, has allowed the deadline for amending its pleadings to pass, and has stated that it is unable to specifically identify any amendments it could make. If the SEC were able to cure the defeats in its complaint, it would have done so by now. But the defects are incurable because the SEC's theories do not support either claims that it seeks to bring or the jurisdiction that it seeks to bring them in. Accordingly, amendment would be futile, as nothing in the record suggests that another complaint would remedy the legal deficiencies set forth above. Then there's some citations. Conclusions. For the foregoing reasons, the complaint should be dismissed with prejudice in its entirety. And then there's some attorney signatures and some contact information for those of you guys who want to reach out to these attorneys who wrote this stuff. So there you guys go. There is Richard Hart's reply brief. You heard it here first, or maybe you heard it somewhere else, but that's it. So
That's all she wrote. Well done, Will.
Boom.
Good job.
Thank you, sir. That was
Alrighty. I'm going to give you a little bit of a break there. We're going to hit some chats real quick because we got a lot stacking up.
I like it.
So, first off, we have one of the fellow based crypto bros, Chad Donner-Schwantz. He says, "We are back." Yes, we are. And 54 Cent even chimed in and said, "And we're back." That we are. Cassie Kelly chiming in about the timing of the length of the shows, and she goes, "Bruh."
Dude, so if we add all the streams together, we did what, 4 hours 17 on the last one?
We're at like 5.5 right now.
Bro, we did it. We did it.
Speaking of which, Paul Sachs says, "It's the stream that never ends. It goes on and on, my friends." We even surprised Nate. He says, "Wait, how long are y'all going for?"
We're going the whole fucking way, baby. Watch the SEC pop out a response to Richard Hart. We'll read that bitch too.
Watch the SEC pop out a response to us. Ugh.
Oh man, that'd be pretty cool. I would be
and
flattered.
then we had, honestly, what I think who I think is the man of the hour, and that is Nuclear Herbs. Big shout out and thank you to him for showing up in the comment section, providing some really good context that we probably were missing or overlooking, partly because we were just trying to read the document. But the context here is phenomenal, and this is precisely the kind of stuff that you really can't get anywhere else. So go check him out on Twitter. His tag is exactly how it's spelled there, Nuclear Herbs.
Dude, we got Nuclear Herbs watching. Oh, I am honored, sir. Thank you for hopping in. This is kick-ass.
Oh yeah, I shot him a message and I was like, "Will and I have bitten off more than we can chew." We read the RH response and then the SEC response in their entirety on stream, and then as soon as we wrapped up, we saw RH response to the response. So guess who's on hour 5 of streaming today? He said, "I can't even imagine trying to digest it all live. Good luck."
Yeah, this is
much appreciated, brother.
Yeah. This is some. I have not read something out loud that long in a very long time.
That was basically an hour you went for there.
The most I ever did before was like running rifle range on the Marine Corps, but there's lots of pause in between like the stuff that you're saying. So that's
for sure.
That was good times.
I should probably read the comment. So the first one here says, "The SEC loves citing PlexCore because it was decided by Judge Amon." Same judge here. "The problem is that the facts of the case are wildly different to anything that Richard Hart did." Well said. All right, up next, we got Hexagon Lust in Asia. "Judge, you can't sue software counsel." Yeah, sorry, I think one of the arguments previously made was that you can't sue a sidewalk. It's like, yeah, that sounds about right here. We got Nuclear Herbs. He says, "Thanks, I enjoy the stuff. I'm going to enjoy a lot more when the SEC loses." Aren't we all? Aren't we all? He also follows it up. He says, "You can tell how critical the jurisdiction issue is just by just how much both sides dedicated to it in their briefs." Yeah, the jurisdictional thing is a big issue. I gotta say, I think the Richard Hart double response here is it does a very good job of correcting timelines that the SEC kind of left very vague and ambiguous. And they do a very good job here of showing specifically that actions and efforts were thought out in advance and specifically taken during specific times to be well within legal means. And just because you were invited to receive an award live on a conference show doesn't mean that you're trying to target that audience. So I'll say there's some good stuff there. Again, another case, Zippo, was one of the cases referred to. He says, it's a pretty old case now, being decided somewhat early on the internet days. It's still good law, but website tech has evolved so much that the sliding scale in it is kind of obsolete. So if you remember from the SEC response that I read, they talked about the sliding scale in this one, saying that it's either like you're pretty much fully interactive or this is like not interactive and just displaying information. He also throws out, you're going to hear the term suit-related conduct more than once at the hearing in October. I would agree. The idea of suit-related conduct seems to be one of the things that the response here focuses on very much, which is that the SEC is trying to just like take all the actions ever and slap them together and be like, yeah, it's all related. Versus Richard Hart's team's like, nope, this is clearly what this is for. You are misconstruing it or you're misconstruing the timeline. Finally, we got a few other shout outs to give. We got Yellowtail. Good to see you, brother. He says, save Richard Hart 2024. Agreed. We even got Russ saying, hey, DRT. Good to see you, Russ. And we got the Camel Clan showing up with Pulse Jitsu, with Fast Abdul. Good to see you, brother. Glad everyone could be making it. That is what we got for chats. So, and we got one more. Taylor coming in saying, Camel Clan, Token?
There's a gentleman by the name of Genius TV as well. I don't know if you saw.
Oh shoot, yeah. He was he was in here.
Shout
as
out
well.
to Genius TV.
Transfer of power.
Fuck yeah, bro.
True.
Very good.
We have a phenomenal chat going on tonight.
I'm gonna I'm gonna look up that word real quick because that's something that we owe the folks at home. Is
what's the censure?
Yeah. All right.
Censure. I wouldn't be surprised if it's like, I think I might have looked it up once and it's like Cinter.
Scienter, yeah.
Scienter?
Scienter.
Scienter. Okay.
Scienter. Okay.
Learn a new thing every day, folks.
Look at that. I'm also I'm asking ChatGPT how many times they said the word alleged.
Allegedly. All right, while you're doing that, I do want to get the question queued up for you. So now that we've read this, I want to get your initial take on this document, and then we can start going through the arguments and see what we thought about each of them. So overall, is Richard Hart's legal team worth their weight in gold? Yes or no?
Oh, yes. Hell yeah, bro.
This was fantastic in my personal opinion. Like
I'm glad I got to read that.
Oh, for sure. When we wrapped the stream right before this one of the things we were talking about is like Richard Hart's team is made up of very active prosecutors who are very involved in the process and are actual like court trial lawyers. And I think that this document right here really proves that these people know what they're talking about, and they're very well versed in everything going on. And they're really good at making the arguments very particularly and precisely. I think the SEC kind of got away a little bit with in their arguments about very broad generalizations of things going on and trying to fit it into existing laws in order to go against bad actors, because they do kind of have the scale of power favoring them right now where we are in the process, because their job is to pursue criminal actions. Therefore, they're kind of like, all right, whatever you think is a criminal action, we'll kind of give you the nod on that one, and then we'll go hash it out in court, in which case we give the benefit of the doubt to the defendant.
Yep.
So that being said, I think the response here is spot on with a lot of things. They correct a lot of timelines, which is fantastic. And it is very, very specific in the arguments, which is blatantly different from the SEC response. And they even explain the cases that the SEC was citing better than they do.
It's gonna be juicy, bro.
True. All right, let's go through the arguments again. We got argument 1. This court lacks personal jurisdiction over Mr. Hart. So, how do you feel about that section?
I agree that the court lacks jurisdiction.
So, there were a few big things in this one, in my personal opinion. First off, they drop all mentions of the word alter ego.
Yeah, what is that about? I didn't understand that.
So this is more of reference to the comment I made earlier about people saying that you can't sue the sidewalk. This is previously in the complaint. People are complaining and trying to wrap up Richard Hart, the Hex software, the Pulse Chain software, and Pulse X software, and try to claim that those 3 softwares are just alter egos of Richard Hart. Therefore, anything that you can allege against them, you can effectively leverage against Richard Hart. This is, and they drop all mention of the alter ego idea and instead try to focus very specifically on Richard Hart. It is very telling that the response here says, hey, by the way, that original mention in the complaint, you guys completely dropped it. Therefore, you specifically not mentioning one of your own points of prosecution shows that you made a claim that wasn't really there. Makes sense, right?
Yeah.
All right. After that, we go back to the idea of this is where they clarify the timeline, which is that they tried to say that he was all good. Nuclear Rip says he's back. Sorry, I missed the rest of the reading. You're good, brother. We had a good time finishing it up, and we are just starting our analysis now. So right now we're in section 1 for the court lacks personal jurisdiction over Mr. Hart. We just covered that the alter ego claims were dropped, which is very telling. And number 2, when they specifically call out the very specific timeline about when Richard Hart, where he was, when he was, and what he was saying in relation to what sacrifices were going on or what offerings were going on. Because anytime he talked about Hex, offerings were closed. Anytime he talked about Pulse Chain or Pulse X, offerings were not available or they were closed. Therefore, he's not really marketing something that you can purchase. I think that's good claim to show that he's not specifically targeting things, even if they happen in the United States. Also, the developer claim makes sense because I don't know if this specific claim for jurisdiction relies on intent. I kind of think that because it's a jurisdiction thing, it doesn't rely on intent. Therefore, even if Richard Hart didn't know that one of the developers he hired was in the United States, it doesn't alleviate him of having jurisdiction over him from that territory. But at the same time, overall, I think this argument makes more sense, which is that they kind of just don't have jurisdiction as much as they're claiming to, because they're kind of trying to say that this was targeted to the United States. He's like, no, it was not specific there. Some stuff did happen there, but this was not targeting.
Yep. Yeah, I think that's the weak point. Let me put on my little lawyer hat real quick here. I do agree that the U.S. was not targeted. The U.S. incidentally interacted, and a large portion of the U.S. happens to have internet access. So there's probably a very significant portion of the people interacting with the contract that are in the U.S., but that there's not the target audience to play the technicalities game.
For true. You good on this one? Argument number 2?
Yeah.
All right. Argument number 2. The SEC has failed to adequately plead the existence of a domestic purchase, sale, or offer of securities. So this is a good chunk as well. So they have the section that the SEC fails to allege the domestic purchase of sales and securities. Again, domestic is the key word in this one. And they talk about the Dodd-Frank Act and how it does not override the Morrison application. This one definitely got a little in the weeds for me. But at the same time, I think this is an interesting question moving forward in the legal world, not just because of the case here, but because in my mind, this is one of the first times that I'm seeing a legal team actually argue a federal authority's interpretation of law. And this is partly I think it might be due to the fact that we had the overturning of Chevron deference, which allows people to sue agencies based on their interpretation of vague and ambiguous law. So this might be in that area. I would love for someone to correct me if I'm wrong, but I like the fact that that the legal team is willing to just straight up look at the SEC and say your interpretation of this law is wrong, and you just you just are wrong. So that's good.
It's always good when they put them in that place.
Cool. And then after that, we have, again, it comes back to domestic sales, which is that I think they specify more cases that are referenced and say, look, these cases had people and founders who had knowledge and knew that a small percentage of the purchases were happening in this specific country. That is not the case here. And if these are either okay or very minimally applicable, then the ones
Yep.
that is even less than that is even less applicable. So
Yep.
I like that argument a lot. I think it holds water very well, so to speak.
I'm trying to
Alrighty.
remember the. I was thinking of a different example. Anyways, on to the next one.
Fair enough. Argument number 3. The complaint fails to state a claim for securities fraud.
Mm-hmm.
Again, I mentioned it before. I think the fraud is a very, very weak argument from the SEC. And I think that the arguments they made here made it even worse, which is that the SEC claims fraud because they're trying to just lump everything together and be like, oh yeah, the emissions, and that you have to tell the investors where the money's going, right? It's like, and the mixer is just trying to obfuscate that. It's like,
yeah, that part was that was a bunch of bullshit that like the mixer's trying to obfuscate. It's like, no, he transacted. It's public. Like, I don't think that he ran the stuff through Tornado Cash, if I'm not mistaken.
I don't think so. But in this section in particular, there was one part that they call out that I thought was very, very important, which is that the legal team says the SEC is trying to ignore the very obvious and plain language of Richard Hart, telling people funds in the sacrifice are gone. They are gone forever. There is no way to get them back, and there's no obligation about disclosing anything or using those funds for anything. But instead, the SEC tries to just make some implications and be like, oh yeah, like we all know it's investor funds, right? Like, come on, we all know it's invested to go to the product. It's like, no, you're blatantly ignoring so many statements and disclaimers that he says every time, very strongly as well.
Another one of my
is not invested funds.
I like the part where I think I might be misinterpreting this here, but I think that they referenced a place where, like, if somebody says like, hey, I'm going to steal your money and I'm going to do this, that, and the other thing, like, then it's not considered it fails the fraud part of the Howey test or something like that. I'm totally butchering it right now, but I remember there being an example in there where it's talking about like an investor or someone like saying, hey, I'm going to, illegally steal your funds or something like that. Anyways, not to throw us off the topic of conversation.
No, you're good. Comment from Nuclear Ips. He says it's pretty hard to argue someone defrauded you when they told you exactly what they were going to do with it and then did it. Fraud requires deception. Agreed. I think that all of the arguments the SEC makes on this are reliant upon an implication, an unspoken agreement that, like, oh yeah, this is an investment contract, right? And you have to know where the funds are going. It's like, no, everything is based on trying to claim that they have a duty or an obligation to disclose things that they have no duty or obligation to disclose, because the thing that would assert the duty is also assumed and also false. Yeah, I think the fraud case is very, very weak on this one. And then, yeah, I mean,
I quite enjoyed reading this whole thing, man. This is a lot more fun than I thought it would be. I thought it'd be very droll, very dry, but it was like, nah, dude, this is like Richard Hart snapping back like he does like on stream. Like it was a lot more tame, but it definitely had the essence of like the shut the fuck up, I told you so.
Oh, absolutely. In particular, I like what they talk about in the next section here. So argument number 4, the opposition does not address the complaint's failure to adequately allege that any parties entered into an investment contract. This is the one for me where the Richard Hart team very specifically said, like, oh, hey, you got our brief, and then you responded to our brief, except you didn't respond to anything we said. You instead went off on your own tangent to build a straw man just so you could knock it down. And this is where
that part was the best.
They're like, it's really cool that you spent 10 pages building a Howey test for this thing that you think that we said, but was never said. By the way, your analysis of that Howey test is also terrible.
Yep. Oh,
so
man.
Even your straw man sucks.
It was fucking hilarious, man.
Yeah.
God, I love it.
That was a good one. So the two subparts of this one is that the complaint does not allege the existence of a contract, transaction, or scheme that created continuing obligation for Mr. Hart or anyone else. And then section number 2 was the opposition misinterprets Mr. Hart's continuing obligations as a dispute about a Howey test. So yeah, there you go. I think that this one very clearly shows that, again, it's the SEC just like trying to imply things that are just not there.
That's a they're a little man. I'm not a lawyer person, but it seems pretty fucking obvious to me. So I don't know. Perhaps it's because I'm a little bit I am admittedly a little bit emotionally tied into this into everything that's going on here. But like,
That's fair.
I don't know. I cannot offer an unbiased opinion.
That's true. In particular, this one, if you remember when we did the SEC response, this is the part where they were like very like generally and gratuitously applying the label of we have to observe everything in its economic entirety. And then I think the snapback on this one is like, you guys are really fond of using this wherever and however you want. But the thing that gives you the ability to do that is very specific and narrow in its application as well. And you're also kind of just misconstruing it too. So again, it kind of goes back to the fact that I think the SEC is really reaching and trying to just like rely on maybe some of their prosecutorial authority to be like, oh yeah, these are bad guys, believe us. Meanwhile, the Richard Hart team is like, no, you're just not understanding what's going on here. So finally, we do have, we have two more, not finally. We have complaint number 5, or argument number 5, which is the complaint unconstitutionally infringes on the First Amendment right of Mr. Hart and thousands of individuals who use Hex, PulseChain, and PulseX. Again, going back, referencing the stream we just wrapped up. This is the one where I said that it felt like the two parties were just talking past each other. And obviously the Richard Hart team talked first, which is what warrants a response. So when the person talks past you, that is not a response. So in regards to what the SEC said initially in their thing was, oh yeah, well, just because it's the First Amendment doesn't mean that you're protected from like this being used against you. But then the argument that they make back here is that no, you specifically cherry picked very clear and obvious protected political speech, and then use that protected political speech as the entire basis for turning something that is fine into something that you claim to be a security, purely based on the fact that he is arguing against the current system or whatever politically protected speech is in place in your organization. So out of a 7 or 8 hour stream, they found a few snippets and then said, because this person expressed their opinion, it means everything they've ever done is a security. It's like, you sure about that, boss?
Wouldn't that be fucking crazy? Like if there's some like snippet somewhere of like, I don't know, fucking Bill Gates or like Steve Jobs talking about like how they think that their product's pretty good and it might do really well later. And it's like, we got you. Like it's fucking ridiculous. It's fucking, they did, man. Like, I can't word it as well as the team did, but I'm on the same page, man.
Agreed. Nuclear Herbs coming in here. He said the SEC missed the point on the 1A argument entirely. I don't think they actually got what RH is arguing. I'm going to take it a step further than you, my friend. I don't think they want to talk about what RH is arguing on the First Amendment claims, because I think they know that as a governmental organization, they know that that is dicey territory and very typically usually cuts against governmental action. In particular, I think when they talked about the alleviating or the actions that are being requested to create what's the word I'm looking for? Relief.
Okay.
It is so egregious and aggressive that it cuts against other people's First Amendment protected speech, which is the ability to interact on the blockchain as the public square, like they talked about. What they're saying is that even in the intermediate interpretation of how hard your actions are cutting against free speech, it is the fact that you are now curtailing average, normal, innocent people's right to free speech in order to try and curtail what you perceive as illegal speech. So you're infringing upon 10,000 to infringe upon the alleged actions of one. Yeah,
that they haven't like proved is a security, right? So like
these are all just allegations.
Yeah, and so like they correct me if I'm wrong, but I think that there was a point made that like that's a bad thing to do, even if the thing's a security, which you haven't determined yet, anyways, and you're trying to use this free speech that to prove that someone's talking about a security when like it's like a fucking circular like time traveling logic fuck around thing or something, right?
That's true. I think you're entirely correct on this one too, which is that this is the example of, look, Like you are infringing on so many other people because of something that is not even argued or finished yet. That's not due process. That's not due process at all. So I know that the First Amendment arguments sometimes get a little nebulous and a little bit like hippy dippy feely, but at the same time, this argument, this one is very important in particular, and it's not even making like the typical arguments of like, oh, like I have the right to say mean things to someone. It's like, no. It is me producing something that is a work product that is protected. And you trying to say that the work product that I create because it's code and you don't like it, you think it does something bad, that I can't produce this, talk about it, or proliferate it to anybody else. That's the issue here. And this is one of those things where they specifically reference one or a bunch of those previous cases that talk about how code and things that are produced online and free or publicly available information, these are all forms of free speech. Curtailing that is a serious issue because you're going to curtail not just the crypto industry in general. If people are passing around open source code and whatnot to build things in the future, you're going to effectuate all the stuff that is proliferated and all the future things that people could build. A lot. Shoot, I gotta find this earlier. It's this one. The comment about you can tell how critical the jurisdiction issue is by just how much both times dedicated to it in the briefs. It's not just that. It's that the entire case is very important. And this is me trying to do a bit of a meta-analysis about the state of lawsuits in the US right now, which is that we don't really see a whole lot of cases actually go to trial and be adjudicated because it creates precedent. I think that the parties are very hesitant right now to create precedent about what is and is not allowed in the crypto industry on both sides of the aisle. Because if the SEC gets ruled against and keeps getting ruled against, it's going to start creating more and more restrictions on the SEC and opening up more space for the crypto industry. Additionally, in the crypto space, as developers, if you get ruled against, then that means that your entire market share and your entire ability to create the crypto economy effectively in the United States anyways starts getting hedged in more and more guardrails and higher walls get put up around you. It's kind of this like weird prisoner's dilemma where like neither people are willing to commit, but this case right here, it seems like a very obvious case where both parties are staring each other square in the face and nobody wants to back down, which means it's going to go to trial and a decision is going to be made and precedent will be set. So unless one of these parties decides correct. So unless one of these parties, either Richard Hart's team or the SEC, is willing to lose the game of chicken, so to speak, and back down, it means that we're going to continue on this path to something that we've probably seen very few times before. Yeah, here we go. Accurate. The SEC brings a lot of cases in the Second Circuit. Bad precedent at the appellate level will cripple them. Agreed. Yeah, because remember, this is a district court. This is not like a local court. This is a district court. The only thing higher than this, correct me if I'm wrong, is the Supreme Court, which I don't really think they've taken many crypto cases. It's been a hot minute since they've taken a real First Amendment case as well. But at the same time,
that'd be cool.
Losing here in this circuit, where, by the way, the SEC is homed in New York.
Yep.
That would be very big against the SEC, in my personal opinion. And then we still have one more argument, and that is the argument of, hey, SEC, you can't just revise your complaint whenever it suits you. You got to go with your actual complaint. I like this one a lot. This was kind of funny.
Yeah.
I thought this was very tongue-in-cheek, which was their initial argument was so bad, they keep trying to revise it. But no matter what they revise it to, it still sucks. So the argument's kind of like, there's no need to, because it makes no difference.
Ample opportunity to present its case and further amendments would be futile.
This is kind of scathing in my opinion.
ChatGPT shortened version.
Alrighty, Will.
That was that last set of paragraphs, I think.
Yeah, it was like the last one before the conclusion.
Hey, unfuck yourself, you idiots! Like, what are you doing here?
It's this half page final little jab that's just like that little kidney shot that you just feel. It's just like, oh. All right, so now that we've gone through everything, we've gone through the arguments, how are we feeling? Do we need to revise our percentage predictions for RH win?
well, I can't do 5,555% that he's going to win because that's a little over 100%. But
I was going to say, if you did
I'm feeling good.
55.55, that would be a revision downwards, which wouldn't make
Yeah,
a lot
which
of
I
sense.
can't do because I've already given it the 69,420. So I'm going to stick with my original 69,420, and I'm just going to hope that I'm wrong to the to like I wasn't high enough in my predictions, which is good.
What do you think about this one?
We will win some based crypto, Chad. Probably. Fucking A, right, Chad Donnerschwanz. Fucking A, right. Shout out to all the fellow
Yeah.
based crypto Chads out there.
So the last stream, I gave it a 2-to-1 Vegas odds, aka 66% chance RH wins.
Yeah.
I'm feeling even better than that now. I'm
Yep.
willing to go to the 75%. That's 3-to-1 Vegas odds that RH is going to win. I think it makes sense because the SEC made a lot of very broad and sweeping claims in their thing that I was relying on and assuming that an institution is just going to kind of like head nod and agree with them on. But the response here is this was a scalpel.
It's
this
confidence
was very
inspiring for sure.
Yeah, this was specific and pointed, very specific and pointed to about each of the claims that the SEC makes, and I don't see any one of them that really was left uncovered. We might have to revise our probability statements here. So Nuclear Herbs is saying motions to dismiss are probably granted 10%-ish of the time. I'm not going to make a prediction, but I think this is much higher. I would agree. For the motion to dismiss, I think there's a good chance. I think what we were referring to earlier was the probability of winning at trial based on the arguments we've seen here.
Total wins. Yeah.
As far as motions to dismiss goes, I think this has a much higher chance of being dismissed than anything in the past. If anything, this might be a bold claim. I would not be surprised to see the SEC actually vacate the claims entirely. We've seen them do similar things recently with the investigations into like Ethereum, and we've seen some very recent rulings against them when in cases of like the XRP case.
Yep.
And I think that the momentum right now is so far against the SEC that I don't think it's too far out of reality to see them starting to pick their battles, so to speak, and say, all right, we might be a little over our skis on this one. Let's pull it back and try to focus efforts elsewhere.
Or they're looking to stack losses. That's what they're into now.
Dude, if they want to take this to court, take it to court. You're going to get an L. Like the way it's going right now, you're going to get an L. If you want to save face and maybe try not to get fired, Gary, may I consider retracting?
Maybe Gary's actually on our side. Maybe he's just trying to drive the whole thing into the ground and like do it in like a ball of flame. Yes, get out your tinfoil hat. I've crumpled.
That's where this is right here, which is that Gary Gensler is on our side, and he just wants to run it so poorly that he gets ruled against, and we have permanent precedent for crypto.
Bro, that's what it is, man.
I'm not in that camp. I've heard this argument before. I understand that there's a weird theory that you can fail upwards in government and no one ever actually is like pays consequences for their losses. So yeah. Ooh, we got a good comment here from Chuck. He says near 0% chance this goes to trial. If it makes it past the motion to dismiss, this will be decided on summary judgment, aka the judge just makes a judgment from the bench pretty much without a trial. That'd be interesting. I was just trying to read the documents. The SEC posted on their thing, request jury trial. So that's me. I'm just reading what they say. But I think that this right here, this makes a lot of sense.
Yeah. It would be nice to see. Oh, we have passed the threshold, Zenith.
For 6 hours.
Been streaming for 6 hours. Half of the day, baby.
Do you remember there's a SpongeBob episode where Plankton opens the chum bucket for 23 hours a day as just a pure psychological move to make Mr. Krabs keep the Krusty Krab open for 24 hours. And then he just has a montage of like, we're going on day 7 of no sleep, day 7. Then he just keeps going. It keeps getting worse and worse. Hopefully that's not our stream, but I don't know. Saying like hour 6 reminded me of that.
I think we could do it. We'd have to check out though.
True. Chuck, I do have a bit of a question for you. Hopefully it doesn't take too much to answer. You mentioned that previously one of the cases was actually decided by the same judge that is overseeing this case. And, oh gosh, you're going to have to go find this. The PlexCore case. So if I remember correctly, PlexCore was one of the ones talking about how there's jurisdiction here, even though the person was acting abroad. Do you think that because we have the judge from that case, we might see a similar ruling here where they don't take up that the jurisdiction argument, and that they don't agree with Richard Hart's case, and instead they kind of purport to the old standards, so to speak, and actually like rule against RH on this one. I don't know. Might be a bit of a stretch, but I think it's possible. The question of how much do you think people can change, specifically this judge in the second court, in the Second Circuit Court. So I don't know. That's my thoughts.
There we go.
Here we go. No, facts are way different. In PlexCord, they did tons of stuff in the US. In USD, excuse me. They made if I remember correctly, this is the one where they say like 90% of the transactions were done in US dollars. So fair enough. That's compelling to me. So hopefully it's compelling to this guy.
Well, all right.
All right. Will, let's go ahead and get our final thoughts going. Anything new? Anything different other than just more hopium?
Yeah, it was nice to have that little injection of hopium after like we thought everything. It's nice to end on a note from our fearless leader, as opposed to like some shitty unkempt thoughts from the Securities and Exchange Commission. So I'm just glad that we were able to, that like we just happened to be. Shout out to Nuclear Herbs. Scrolling your Twitter is what made me realize that, oh shit, there's another document. Z, we got to go back on, bro.
Yeah, look, I'm not going to say that you did this to us, but like
I observed the information, and now here we are having a great time. Having a good time.
True. You know what? We're already here. We might as well. Let's show him one more time. Ladies and gentlemen, we have Nuclear Herbs on Twitter at Nuclear Herbs. He says, nothing I say is legal advice. Mostly retired, attorney, Navy vet, 2-time Ironman, 140.6 finisher, and 2-time beer hockey champ. Pulse Chain Law School, only accredited in Hexco. By the way, if you're not part of the Pulse Chain Law School, go check out the Pulse Chain Law School that he runs. If you like this information and you want more, that's where you get it, baby. But yeah, other than that, this Twitter is it's a good time.
There's the that post right there.
The one that started it all.
That's the one that got us going. Or fucking kept us going.
So this was obviously very off the cuff, and Nuclear Herbs made it very clear that when he talks about this, he's going to be more measured and study and take notes and read this through multiple times, as opposed to just kind of go off the handle like we just did. But
yeah, we're here to slap you upside the head for 6 hours and keep you guys awake. And he's there to actually give you the good, thoughtful information and everything. So
true. Hopefully everything we said is mostly accurate. If it's not, please let us know. I'm more than happy to make a correction or a retraction. But other than that, the point was, this is now in audio form. So if you would like to listen or share this with someone who wants to potentially know what's going on here but doesn't want to sit down and read the document, show them the video, the stream, and tell them to put it at double time speed, and they can blast through this document. It'll take them about half an hour at the most. So there you go. Other than that, much appreciated, Chuck. Final time. Boom. Right there. Go check out the Twitter. Excellent. If it's not, if the man of the hour right now is Richard Hart, but if there's a second one, it's this guy right here. So much love. We'll see you in Vegas next time, and hopefully I'll see you in October if travel's permitting for you. Don't want to give away too much, but hope you're doing well, brother. Really hope so.
Hell yeah.
Will, anything final? Do we gotta?
I think we should during our outro we should play the Pulse Chain conference commercial.
You want to do the ad? You want to do the ad?
There's never a bad time to play the ad before the Pulse Chain conference happens.
That's true. If we're doing 6 hours of show, I think we can play one ad where we get maybe, possibly a little bit of a ticket to an event that we're already going to and paying for. So there's that. Other than that, Will, where can the people find you?
Folks can find me. All of my socials you can find at will.pls.fyi. All of my everything is linked there. Oh, fuck yeah. We'll see you over there, Mr. Nuclear Herbs.
Brother.
Both Zenith and I are going to be there. So you guys heard it here first. You guys can find everything that I do branched off of will.pls.fyi. You can find and stalk all of my socials there, whether you want to check me out on Facebook or on Twitter or on Instagram or on X or on Telegram or whatever. I have my Linktree linked in there as well. It is linktree.com or linktree/Will Stevenson. That's where like a lot more, that's more focused on like some of the digital work that I've done, whether it's like writing a silly little book or creating a Rule Zero archive or like some of my other little pet projects. All that stuff can be found in there. I'm going to actually take the time right now to go ahead and shout out a thing that I've created a long time ago, and it's a little spreadsheet that's just linked up in a Google Drive. It is called bit.ly/crypto_bro_services. This is basically just a list of people that I've found that they do things in the real world and not just like, hang out and do crypto stuff. Like these are crypto bros that like, make moccasins, or they write web pages, or they, they build houses or do ironworking, or like do strength and conditioning training, things of that nature. So if you guys want to hook up with other folks, or if you want to put in your own information in there, like dox yourself to whatever extent you're comfortable with. Anybody can edit that document. So I just ask that you're not an asshole and don't delete everything, because that would be a dick move to do. And I'd have to go find my copy and implement. Actually, I'm going to make a copy of it right now before anyone goes and does that. But anyways, just like if you want to have other people, if you want to do business with other people in the space, then like, you can go in there and you can put in like, hey, this is what I do. This is where you can find me. This is like some of the services and products that I offer. Like there's a lot of Hexicans that make jewelry. There's a lot of Hexicans that make t-shirts. There's not a lot of Hexicans that I know of that are What was that? What was that dude who talks about the Riptich man in Babylon? God damn it. I was going to shout him out real quick.
Oh, chiropractors, Dr. H.
Chiropractor. Yes, Dr. H. There's not a lot of people in the cryptosphere that are chiropractors, but you guys can go and find all sorts of people that do all sorts of things at this bit.ly/crypto_bro_services. Again, this is a public document. So like, don't put down anything that you're not willing to share with the world, right? So some people are comfortable being doxxed, some people are not. So if you want to do business with other people, then that's a public place where you can find information. Other than that, that's all I got. Also, always visit bit.ly/hex_meetup. That's a little Hex Meetup community chat that I have made as well. I guess I'll go ahead and drop that link in the chats too. But that's all I got. Zenith, where can the folks find you, and what have you got new and exciting coming up in the near future?
Ladies and gentlemen, you can find me on Instagram and Twitter at ZenithDI. Other than that, 8 p.m. Eastern Time, Friday for book club, Sunday for the main show, where I guarantee you we will be talking about this to some extent. And next Wednesday, we have a special guest. Check out the Sunday show for the announcement. Other than that, again, guys, time is your most valuable asset. Thank you for spending about 6 hours of it today with us. We hope to have provided you with some value to either you or anyone you share these videos with to just help get exposure on what we're talking about. But until then, I hope that you all degen responsibly. Ladies and gentlemen, welcome back to the Pulse Chain Tour Masters Golf Tournament 2024. Zenith is making his approach to the green on this sudden death playoff between himself and Reginald Gerald III, who already completed his putt for birdie. Zenith needs to make this putt right here in order for his dreams of winning that jacket to stay alive. Let's see what he does. Oh, he flubbed it. He missed. He whiffed. He's a loser. I repeat, RG3 wins. RG3 wins. Don't make mistakes like that guy. Get ready early for Pulse Chain Tour Las Vegas 2025, including the Pulse Masters Golf Tournament from March 6th through the 9th. Sign up early and use the code DGEN at checkout before September 1st to get 36.9% off all of your tickets. Don't miss out on all the fun from the star-studded conferences, golf tournament, and nightly events in beautiful Las Vegas, Nevada with all of your friends and favorite Pulse and Hex creators. We cannot wait to see you in Vegas, so until then, degen responsibly.